Welcome to FFRF's Ask an Atheist. I'm Sam Grover, Associate Counsel at the Freedom from Religion Foundation, here in studio in Madison, Wisconsin. Joining me via Skype today is Patrick Elliott, FFRF's Senior Counsel.
Happy to join you, Sam.
Happy to have you, Patrick. Today we are going to be discussing the oral argument that the Supreme Court just heard this morning in the case Carson v. Makin, a case involving claims that taxpayers must fund religious schools.
And we'll be providing our immediate reactions to what we heard in the argument, which just finished up. And we're going to be joined today by a special guest, Professor Caroline Corbin. She's a professor at the University of Miami School of Law. Professor Corbin is an expert on the First Amendment and the religion clauses specifically. She's written numerous law review articles, seemingly one or more per year, including on issues like Christian nationalism, COVID safer at home orders, legislative prayer, and many others. Professor Corbin, thank you for joining us.
Thank you for having me.
And as always, for those watching, you can join our conversation by making comments in the Facebook comments or by emailing us at askanatheist@ffrf.org. So I think we can jump right in. And Sam, if you want to give us a little background, about the case that the court was hearing this morning.
Yeah, sure. Before I do my 30-second take, I have to recommend an op-ed by Rachel Lacer of Americans United for Separation of Church and State. She wrote it in the Washington Post 2 days ago, and it lays out the whole story better than I'll be able to in 30 seconds here. But to summarize, so over half of the 260 school districts in the state of Maine don't operate their own high schools because the area is either too small or too remote or both. Instead, Maine has a tuition assistance program that pays for students to attend public and private schools so long as those schools are not providing a religious education. So the plaintiff in the case, the original plaintiffs are two families who wanted to use state money to send their children to private Christian schools that the state has determined are providing religious instruction to students. And that fact is not in dispute. One of the schools in question, the Bangor Christian School, has a mission of instilling a biblical worldview that is, quote, completely intertwined with the curriculum and identifies the Bible as its, quote, final authority in all matters. The other school, Temple Academy, likewise offers a biblically integrated education. And additionally, neither of these schools will hire teachers who are gay or who do not identify with the gender they were assigned at birth. Okay, now importantly, the state does not exclude all religious institutions from receiving funds under its tuition assistance program. The schools at issue in the case would still be eligible, even though they are religious, except that they choose to provide sectarian education to students. This limitation in the tuition assistance program ensures that Maine taxpayers are not forced to fund religious education and proselytization.
Thanks, Sam. And I guess, Professor Corbin, I know you're familiar with the case. I don't know if you have anything to add just in terms of the facts, because obviously I think the court today kind of got into quite a bit about what was and wasn't happening in Maine.
I think one fact that particularly struck me is that this is really about Maine's public education system. And so most of Maine's students go to public school or to a nearby public school. I think the fact they said is like at least 98% of students in Maine, it was part of this public education system, go to a public school. It was just a small percentage who might be part of the Maine public education school where Maine is funding them to go to a private school for their Maine public education.
Yeah, it's really, and Sam is actually from Vermont, so I don't know how this works in some of the other northeastern states, but it seems unique just in terms of how education operates there, because some of these, they call them, I think, educational units, but school districts basically don't operate a secondary school. And so really it's not a matter of choosing their normal high school and then picking another one. It's what school could they go to? Most of those students are then going to one particular what they call like a town school, which is a private school but is funded by the state, if I understand that correctly.
Yeah.
But so we all listened today to the arguments, which I guess I'd first, Professor, start with you. I don't know if you have any general reactions or comments, coming on the heels of the argument.
Unfortunately, my takeaway, and again, I didn't count the votes, but my overall takeaway is that the Supreme Court is going to continue on its path of eviscerating the Establishment Clause and aggrandizing the Free Exercise Clause. And so I think they're going to argue that refusing to fund private religious school amounts to unconstitutional religious discrimination, and simply pretend we have no Establishment Clause or Establishment Clause values.
Yeah, that was sort of my general takeaway as well, that the state of the Establishment Clause is that it's more or less non-existent at this point. Go ahead, Patrick.
Go ahead. Well, it just seems that, this is coming, this doesn't occur. I guess why it wasn't a surprise to some of us who work in this area is it's kind of flown from what's gone on at the Supreme Court in recent years with some other cases. So Trinity Lutheran, a case where the court ruled that the state of Missouri had to fund, playground grants to a church-run school, basically. So I guess I don't know if Professor, if you maybe want to comment more broadly on this trend. This is coming after case, they're all coming the same way, and so maybe that's why we're not as shocked as we would be had you gone back 7 years ago or something.
Yeah, I mean, if you go back far enough, and it's not that long ago, that the constitutional question with regard to government funding of schools was whether it violated the Establishment Clause. So first, the court made clear that, at least with voucher programs, it's perfectly constitutional. And then it started going down this path that the Free Exercise Clause actually requires funding to religious organization. And it took its first step with the playground, where it said, granted, it's a playground at a church, but this is a secular endeavor. So you cannot exclude giving a grant to a church just because of its status as a church, because after all, it's going to use the money for the secular purpose of making its playground safer. And then it took its next step with Espinoza, where it was a scholarship program for students at schools. And once again, it held that the categorical exclusion of religious schools from the program was once again discriminating against the schools based on their status rather than their use of the funds. Because again, there's this idea flowing from the Establishment Clause that the government should not be funding religious indoctrination and proselytization.
Yeah,
and so it was still insisting on this distinction between religious status and religious use. It may be that this is the case that simply eliminates that distinction and says, listen, if you're going to fund private secular schools, you must fund private religious schools as well.
I think we actually have a clip from the oral argument here. Bruce, it's going to be the second quote here from Justice Kagan asking a question specifically about this distinction between religious status and religious use.
Zillman was a case in which the question was, could a locality implement such a program? And the question here is different, does the locality have to implement such a program? And what we have often talked about in our First Amendment religion cases is this idea of play in the joints, that not everybody has to follow the same model, and that there is some amount of funding which is neither prohibited by the First Amendment nor commanded by the First Amendment.
Okay. So a slightly different quote than the one I was asking for, but this is actually probably a good primer, a good background quote to have. Justice Kagan here is asking about the play in the joints between the Free Exercise Clause and the Establishment Clause. Professor Corbin, do you have any thoughts on where that play in the joints exists today and the relative power between the two clauses?
Yes. So the play in the joints is this idea that even if one religion clause does not require an action, you can still let me give you a more concrete example. So I think the answer is the play in the joints still exists for the Free Exercise Clause, but it's not clear whether it still exists for the Establishment Clause. So in other words, even if the Free Exercise Clause does not require the government to help religion or facilitate religious exercise, the government may voluntarily do so. On the other hand, even if the Establishment Clause does not require a restriction on government funding to a religious organization, the play in the joints previously would say, well, a state could still decide to advance Establishment Clause values and decide not to fund religion. Here, that may no longer be allowed. It may no longer be the case that if the Establishment Clause does not require a limit, a state can nonetheless still decide to limit its funding of religion.
Right. And by sort of neutering the Establishment Clause, by getting rid of that play in the joints that the clause is supposed to allow for, the certain justices on the Supreme Court seem to be basically eliminating the effect of the Establishment Clause altogether.
Yeah, and again, what's really important to understand is it's one way. They're not eliminating the play in the joints when the government tries to help religion. It's only going to limit play in the joints when the government tries to further establish clause values.
Right.
And why, this is obviously a frustrating to a lot of us who, come from a perspective that the Establishment Clause, should have meaning and is important. And Sam, I know you were the primary author of an amicus brief that we filed in this case, at least just talking about, I guess, the question of today's show, whether if there are taxpayer interest in not funding religion. So I don't know if you want to comment a little bit on that. And it's a similar brief that we've written in other cases, but it seems to be totally lost that there was this idea that funding or advancing religion by the government itself was problematic. And now we've gone so far away from that, it seems that the courts just disregarded, those ideas or those ideals.
Yeah, I was disappointed, actually, that I don't believe that the rights of Maine taxpayers were really addressed at all during oral arguments today. I certainly didn't hear it. They talked about the free exercise rights of parents to choose religious education for their children, a right which is not really at stake here since the choice remains open to them, regardless of whether they're using taxpayer funds to fund that education. But every taxpayer in Maine should have a right to have their money go toward secular interests. It should be funding the government's work and not the work of private religious entities. So with that in mind, why don't we go to our next clip here. This is Justice Kagan talking more about the status use distinction, which we were discussing earlier.
The state generally doesn't have to subsidize exercise of a right. We can't put you in jail for saying something. We also can't deprive you of an unrelated benefit for saying something. We can't say you don't get food stamps because we don't like your speech. But that doesn't mean we have to pay for your speech. And we do that all over the place in constitutional law. We do it in the Free Speech Clause. We do it in other areas as well. And so the question here that the status use distinction raises is, why is religion different? Why does the state have to? Not like some states want to, but this state doesn't want to. Why does the state have to subsidize the exercise of a right?
Professor Corbin, do you have an answer to that question?
No. And of course, the first thing that I thought of when I heard about this is the government funding cases in abortion, right? You have a constitutional right to an abortion, at least you do now. It's another podcast. But the government, at least according to the Supreme Court, is under no obligation to pay for your abortion. Likewise, you absolutely have the right to send your child to a private religious school, but similarly, the government should have no obligation to help you pay for that exercise of a right. And that was the point she was trying to make. Our Constitution is generally one of negative rights, not positive rights. The government can't stop you from doing something, but it doesn't have to help you or pay for you to exercise your right.
And your mention of last week, I guess 1 week ago today, it feels like forever ago, the Supreme Court was hearing the abortion case, Dobbs, and I know you were live tweeting or tweeting as the arguments were going on, and I guess I just wanted to ask generally, both because of last week's argument and today, I was kind of struck with the quality of the arguments, particularly from some of the conservative justices, really seemed to be at an elementary level or something. I don't know that there was a high level discussion of some of these issues that you're talking about. And I don't know if you agree or kind of what your take is between, both last week and this week in terms of how the justices are handling these arguments in contentious cases.
I don't know if I can speak to the quality of the questions, but I do think what they both have in common is advancing a particularly Christian nationalist view of what the law should be in this country, because it is my personal opinion that abortion bans should really be considered an Establishment Clause violation, as they're basically codifying a particular religious view. And then again, in today's decision, we see that the court is privileging religion, the advancement of religion, again, ultimately Christian religious schools over Establishment Clause values. So that's the link that I see between the two cases.
Yeah.
Go ahead, Patrick.
I guess the difference is, I'm paying more attention to Supreme Court arguments in cases that we really care about, and I think I guess comparing to prior years' arguments, it seems that sometimes the court is been more willing to engage in some of the philosophy and political discussions that I've seen in some of the other cases. So I think abortion funding did come up as part of a question today. I actually think it was one of the more liberal justices asking it, but it just seemed to me, at least between the last few weeks, or at least the last several Establishment Clause arguments, the court hasn't necessarily stayed in its lane of, we have to decide the narrow issue that we granted certiorari on. I think that they've kind of discussed, at least at oral argument, maybe a wide range of things, and maybe not all of those will end up in an opinion. But I was a little surprised by that, both today and from last week as well.
Right. So, and the way that the Supreme Court is going about taking on this new radical redefinition of religious liberty through neutering the Establishment Clause, I think is expressed pretty well in this next clip we have. Justice Kavanaugh asking why it's okay to discriminate between all religions, why it's okay basically for the government to promote secularism if it's not okay for it to promote a specific religious belief.
So when it says that you can use it for a secular private school, but not a Protestant, Catholic, Jewish, or Muslim, or any other religious private school, you say that's okay, though.
Right. And then I believe Justice Alito says more or less the same thing later on.
When you say a public education, all you mean is a secular education. That's what you mean.
That is the defining feature. And what I would say, Your Honor, is that if you went to...
you have to have a compelling interest in providing a purely secular education in the schools to which these students wish to go.
Your Honor, if you went into any private school, even take Andover Academy. I mean, certainly there are going to be trappings there that are going to be much different than trappings in a public school. But at the end of the day, your chemistry class is going to be taught the same as a public school chemistry class. Your science and math classes are going to be taught the same way. And the one thing that's not going to be occurring in those schools is that they're not going to be inculcating children with a particular religion.
So, Professor Corbin, what do you make of this argument? Do you think that Mr. Taub, the Maine Attorney General, did a good job sort of explaining the difference between promoting religion and promoting secularism?
So, I mean, I think there are a couple of points I want to make. First, I want to emphasize again how these justices are completely reading out the Establishment Clause when they express astonishment that the government might have an interest in offering a secular education, and automatically concluding that prioritizing a secular education is discrimination against religion. It's not. It's advancing one of the first religion clause in the Constitution. Second, I think in their brief, I think they did a better job of answering the question, because they argued that defining the Maine public education was not simply the fact that it was not religious, but that it taught tolerance for all. It exposed people to a wide variety of viewpoints, that this mingling of different people from different backgrounds was really crucial for an educated citizenry. And so I think they tied it also to the idea that it's not just the lack of religion, but there are also certain qualities of being secular that really helped advance the values of this democracy, and values that were necessary for a democracy.
Right. And we know from the facts of this case that the specific schools that would stand to benefit from Maine's taxpayer dollars, if the case goes the way of the plaintiffs, those schools do discriminate against LGBTQ people when it comes to hiring decisions.
So there are two levels of discrimination. There's discrimination in who they hire and the students that they allow in, but the curriculum itself is also discriminatory. So, for example, one of the schools teaches, and this was only very briefly alluded to, but one of them that teaches that the man is the head of both the church and the household, and so therefore is the one who should make decisions. So it's teaching sex, like a discriminatory view of women. And obviously, if it's teaching that homosexuality is a sin, it's teaching a very discriminatory value. And this is what a Maine public education would not be doing.
Right. And so by basically casting off the Establishment Clause or reading it out of the Constitution, the Supreme Court is poised to eliminate Maine's interest or Maine's ability to keep education secular, to sort of to instill a certain set of values that discrimination is wrong, right?
So the only question that remains, and they didn't get into it, but this is the next case, is that the courts could have required that Maine fund religious private schools. And then Maine is going to say, okay, but we're not going to fund schools that discriminate on the basis of race or sex or sexual orientation or gender identity, or teach hatred towards any of these groups in its curriculum. And that I suspect that will be the next case on whether it discriminates against those religious schools that want to teach this.
Right.
But I think now that's still an open question. At least I'm hoping that's the one open question left.
And it kind of makes things a little murky in a sense. And I think our actual brief with the court alluded to this is once the courts go down this road of you have to fund religious schools, is that the next step is that courts are saying, well, you can't regulate religious schools, which normally there would be some entanglement interest in the Establishment Clause to say these schools really don't have to operate. There may be certain things that the state couldn't require them to do because of their religion. But now we're saying not only do you have to fund them, then we now have to decide to what level can the state decide what it's funding if it wants to prohibit discrimination. So we did allude to that, at least in our briefing in this case and in Espinoza. But it seems that the court is either disinterested or first just wants to establish the funding stream before it has to decide that issue that you alluded to.
Yeah, maybe can I just try to summarize this briefly for our viewers who might be getting a little bit lost? Basically, where the line has existed for a long time is that the government has an interest in instilling public school students with a certain set of secular values, not anti-religious values, right? There's a difference between being pro-atheist or anti-theist and just being secular, which is neutrality. So the state has that interest in instilling those values, and where the line should be is that the state can say, okay, we're going to fund private schools that adhere to those same standards, but we're not going to fund schools that want to proselytize or promote religious values specifically. And then all we're going to do when it comes to regulating religious schools is if you want to get government money, we're just going to ask you, okay, are you teaching these values? As soon as you go the other way and say, okay, well, these religious schools can get government money, then you get into this question of whether it entangles the government with religion to have the government sort of actually regulating what those religious schools are teaching.
Or the court will say, well, now you're discriminating against some religions as opposed to others because you're willing to fund religious schools that believe in sex equality, but you're not willing to fund religious schools that teach that men are superior to women. And they will characterize that as discrimination against some religions over others.
So we are getting some questions in, and sometimes they relate to what we're talking about. So I'll read at least one of those right now. This is from Connie Kingsbury, and she asks, so if an openly gay child doesn't have a public school in their area, and their only local school is one of those religious schools, wouldn't that religious school be forced to let that student in, whether or not they like it, since there isn't any alternative?
I think the point now is there are alternatives for students. But the question that is going to be raised is, may Maine condition its funding on a school not discriminating against LGBT students? And that's not entirely clear.
And we've got another question. This is from Ann Benedictson. Are similar problems occurring in other states?
I don't think there are similar problems in other states because it's only a few states, I think Vermont and Maine and maybe New Hampshire, that have this unusual situation where they have a few school districts that are so sparsely populated that they don't actually have a public school available to those students.
Yeah, and I know one thing I'm curious about is, these Supreme Court cases sometimes can change how, schools systems operate in other places. So I don't know, obviously this decision may not impact most places where there's suburban or urban areas, but there may be some states that might move more towards this system, and that would be a concern. And this kind of relates a little bit to another question we had, which basically asks, how is this different? This is from Brian Spradlin. How is this program in Maine different from voucher programs? Aren't they the same thing? And I think that they're very different. And I don't know, Professor, if you want to explain.
Yeah, so it's the motive behind it. The motive behind voucher programs is to expand the options available. It's to provide an alternative to the public school system. So if you don't like the public school system, here are some other places, other things you can go. For Maine, they think of all of this as their public school system, and they simply don't have the resources to have an actual public school in some of the areas of the state. But they still want everyone to have a Maine public school education. So what they're trying to do here is provide alternatives, not alternatives to a Maine public education, but alternative ways of providing a Maine public school education, which by definition is a secular education.
Yeah, I certainly think, though, it's a real possibility that depending on how extreme the court is when they finally write their opinion in this case, it's certainly a possibility that you will see lots of states questioning whether they can continue having restrictions on the types of curricula that schools are providing in order to receive public funding.
Right, and I think the question kind of getting at vouchers, which is probably the bigger nationally issue. Obviously Montana had its program and its state constitution as a part of a prior Supreme Court case. Wisconsin, where FFRF is based, has had the longest running voucher program in the country in Milwaukee. So we know politically a lot of other states are moving more towards this program of education, of sending public money or taxpayer money or using tax credits to fund private religious schools. And it was interesting, Professor, you pointing out, I think some of what these schools are teaching isn't really what a lot of people, maybe they don't know. Some of these schools are terrible in terms of their actual curriculum, their content either being strictly, anti-science, fundamentalist, Christian nationalist. These are programs that are being funded in certain places throughout the country. And unfortunately, I think Florida and Wisconsin may be within those categories of places where this is. I've looked at some of the program in Wisconsin schools, and I think the moniker that people are using is school choice, but reality is I think there are concerns from a policy perspective that taxpayers would be funding some of these schools. So I don't know if Sam or Professor, if you have any take on it's kind of an attack on public education if this is just every person can do whatever they want and we all have to pay for it. So I'll just leave that where it is. I don't know if either of you have a take.
Certainly the way that some of the justices were talking today, they were sort of considering public education itself to be an attack on religious freedom, right? If instilling secular values is not neutrality but is now anti-religious, then you've done away with the state's interest in providing a secular education without religious alternatives.
Although I do think it's important to note that the the attorney for the parents was not arguing that the very provision of public education necessitated subsidizing private religious education. So the argument that the government must fund private religious schools, again, at this point, is only if the government is going to decide to subsidize some private schools for whatever reason, they must also be equally willing to subsidize private religious schools. So I don't think we've yet reached the point where it is no longer possible to only offer a public school education.
I was specifically reacting. Oh, sorry. I was specifically reacting to some of Justice Thomas's comments about mandatory public education. He seemed shocked to learn that states had an interest in educating youth.
Yeah, though again, I think this characterization of secular as anti-religious is really at the core of a lot of thinking and is very problematic because there is a difference between being secular and neutral as to religion and being actively anti-religious. And the first is neutral, the second is not, but the justices don't necessarily see it that way, as you just said.
I was also struck by, and I don't know if either of you picked up on this, when there were hypotheticals being used about if a school were to teach something. One of the examples used was, school would teach against all religions. Basically the anti-religion or atheist perspective. That being as an example that they would even bring up was a little, I don't know if humorous, or the idea that Unitarian Universalists have schools all over the country, and that if we fund those, we must fund the Catholic and Lutheran schools. It read to me as if these people don't know how education actually operates in the United States. I mean, and I know for hypotheticals, you can press points, but I thought it was a little odd how some of those hypotheticals were playing out, and the justices, were asking those types of questions today.
For me, what I found really disconcerting was the line of questioning that was, well, if you're a religious school with a secular curriculum, then you will get funding. But if you're a religious school with a religious curriculum, then you won't get funding. And that amounts to discriminating against some religions over others. And so there was this expressed concern about favoring some religions over others, which is a real concern, but not really the main issue for declining to fund religious education. But what is a problem is if the government is required to fund religious education, that's the rule that's going to end up favoring some religions over others. Because it's going to be the large, already dominant religions that are going to have school and are going to be helped by government funds, and minority religions which are not. And so the Supreme Court is actually going to create a rule that is going to favor some schools over others, which is ultimately one of the things the Establishment Clause tries to prohibit by keeping government funding out of religion.
Well said. Patrick, do we have more questions?
We don't. Let me see.
Oh.
I am unfamiliar with this case, so let me just ask, because Professor, you may. Ann Bedexson asked, does this case relate to the St. Mary's case in Wyoming at all? And I am not familiar with this particular challenge. I know that there's been a challenge, obviously, in Montana, Espinoza, which the Supreme Court ruled on just a few years ago. I'm not aware of litigation on religious school funding in Wyoming.
No, I'm not sure what she's referring to.
All right. Well, I have one then. I was surprised in oral argument today. There were some facts emphasized by the state that that hadn't been emphasized previously. I guess at this point we're down to just one petitioner who's still in the case, asking for state funding to go attend one religious school. And that school has specifically said now that it will not accept the state's funding, even if made available. So this case seems like it's headed down a really bad path in terms of establishing bad precedent. Do we have a way out here by having the justices rule that there's not standing?
I certainly think that they could rule based on standing. But, standing is when they don't want to address the issue. They find standing problems when they don't want to address the issue, and they ignore the standing problems when they want to reach the question. And unfortunately, I suspect that there is a majority of justices who are keen to rule on this based on the actual merits. But I would love to be wrong.
But as a law professor who can sort of neutrally analyze the law, unlike a Supreme Court justice, what do you think about the standing currently in the case?
Well, so the argument is there is no that there's sort of the parents are asserting standing on behalf of the schools, and the schools don't have standing because there has to be an injury in fact that's redressable by the court's ruling. And even if the court were to rule that they could apply, they wouldn't apply So the court ruling wouldn't make a difference. And if a court ruling wouldn't make a difference, then there may not be standing.
Right. It's that lack of redressability, as a lawyer would say, that makes it so this case really shouldn't be heard by the Supreme Court.
But I mean, you could have said that about Espinoza as well. I mean, there were procedural issues in other cases the court just ignored because they wanted to get to the question. But there were some questions about standing. So it's an issue.
Yeah, right. All right. Well, I think with that we'll leave it there. The situation is dire. The Freedom from Religion Foundation will obviously be watching the case as it progresses. We'll see what the decision holds, and hopefully we get a decision that throws out the case based on lack of standing and not a decision that overthrows the Establishment Clause in its entirety. And on that dire note, that's our show for today. So thank you to FFRF's own Patrick Elliott and Professor Caroline Corbin of the University of Miami School of Law for joining to break down this important case.
Thank you.
Thanks, Ann.
Okay, so this week on FFRF's broadcast program Free Thought Matters, Annie Laurie Gaylor and Dan Barker's guests will be Janet Heimlich and Dr. Terry Daniel talking about religious child abuse and how the Bible views children.
The Bible's perception of children starts at a very bad place. When I was working on my research on the Bible, I wanted to find every mention of children in it. And just about all of it was said in a kind of pejorative, controlling way. And then when it was mentioned, it was often about, as you point out, essentially using physical punishment to control their actions. And there are also many just mythical stories in the Bible that present children, as victims of rape, victims of incest, and just horrible, murderous crimes, some committed by Aditi.
You can watch Free Thought Matters on TV stations around the U.S. on Sunday, or on FFRF's YouTube and Facebook channels. And this week on Free Thought Radio, Dan Barker and Annie Laurie Gaylor will be providing more analysis of the Maine Supreme Court case that we just discussed. You can find out where to hear Free Thought Radio at ffrf.org/radio. Thanks for watching FFRF's Ask an Atheist. We will be back next Wednesday at noon Central here on Facebook Live.